We're here this morning to hear oral argument in the case of the city, Elinor McKiel et al., which is the city of Lorain. Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the podium. I'm keeping track of the clock and we'll keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so if you could please remain behind the podium as much as possible and that be the front podium in this courtroom. We had regular briefs and we're ready to proceed when you are.
Morning, Your Honors. Attorney Robert J. Gargis on behalf of the appellant John and Elinor McKiel. May it please the court. Your Honors, we're here this day to ask the court to reverse the decision of the trial court denying the McKiels their motion for attorney's fees and costs in the underlying appropriation action. And when we go back and review this case, it really started in the year 2012 when the city of Lorain was planning to build a road improvement. And on March 13th, they passed a resolution 7-13, and on January 21st, 2014, they passed a resolution 10-14. And those were included in your index as Exhibit B. And what's important about those declarations of the City Council of Lorain is that it was their determination that they were going to take a fee simple absolute interest with no reservation whatsoever to my clients. And so in the process of...
what area are we talking about? How much property?
The property, Your Honor, was about 5,400 square foot.
Was that 7 foot
Yes, Your Honor.
on either side?
And
They wanted that in fee.
yes, fee simple absolute, Your Honor.
Right.
And, you know, so part of this was the fact that, you know, they had their planning and so forth. And when we looked at it, we says, you know, the resolutions say they're taking it fee simple absolute. We don't, except for their graces, we won't have any access to this property. So I'm not denying that they were going to give us graces, but what if when we go to sell the property? So he says, well, how do I get there? You know, for a developer, this is a commercial shopping center area, very much a commercial development growth area. We have to be able to provide them the ingress and egress to this property. So the damages, you know, for the appropriation are significantly different if there's ingress and egress issues. So our appraiser, you know, said, hey, yeah, this is, you know, $382,000 worth of damage, at least. And
Was that pretty much,
or 682, excuse me, 682.
would that be saying that there's, because you've taken away our ability to get in off our land is worthless, so you need to pay
Well, not
us
worthless,
everything?
not worthless, but that is the damage that the appraiser came up with first time around, assembling the
Because
four
there's no way to
parcels.
get there.
Correct. The city could, like the case that happened down in Columbus, you know, just build a guardrail and prohibit your access to the property. Okay.
No, folks, if we want to do anything any time for rebuttal.
Yes, Your Honor, if I could reserve 3 minutes. Also, Your Honor, I'm going to be leaning on this thing a little heavy. I got some myopathy and issues with my back. So I guess the trial court's error was in, you know, when the city went ahead and appreciated the error that they had created, they went ahead and they passed new ordinances and resolutions, and they did that on July 20th of 2015, and I made sure that those ordinances and resolutions were filed with the probate court on July 31st, 2015. What they did at that point was that they corrected that so that the McKiels would have access to the property. And of course that changes everything by way of the litigation. They have to get, the appraiser has to come back out, new opinions, the complications that were once there, you know, are now lessened. And the trial court did not find, you know, that alteration of the take okay? The trial judge said that was insignificant, it was just a change in legal descriptions. But that's not true. I mean, the legal descriptions remained the same from the very beginning to the very end. There's been no change in the legal description.
So it's the same 7 foot?
Same legal description, meets and bounds, or they do it by, GPS. They figure out exactly, pinpoint, legal description. It all stayed the same. They didn't change that. What they changed was the estate that was going to be taken. And I know that this court has wrestled with, fee simple absolute in a recent case where it had to do with a walkway and people's accesses. And that's what I think is applicable here too. When you change from a fee simple absolute to a lesser fee, you've made an alteration. You've made an abandonment. And partial abandonments cause the protections of Revised Code 163.21A2 to apply, as is cited in the case law. So what does that do when they take a lesser estate? Well, that leaves them open, to have to pay the expert's fees, the attorney's fees, and so forth. That's what the state says in the revised code section. It's supposed to be applied in a remedial fashion so that the owner, isn't bullied or stuck, with some overreach, overtake, which is what happened in this case. And then we go to the fact that, the court, I think it was a clear error when he says it's just merely an attempt to correct legal descriptions. No, it's really an abuse of his discretion to invent some kind of a reason why, that we don't get attorney's fees because there was a change in legal descriptions, when there wasn't. I mean, that's just an invention, a creation by the trial court. Just like when a trial court abuses discretion by saying, hey, the road improvements were completely done, when their own project engineers and city engineer testified that mounds and grading and so forth that was supposed to be done was not done. I mean, that was their testimony. I have that cited in the brief, chapter and verse. Yet the trial court found that everything was done according to the plan. Well, that's impossible. It can't be. So what do we call it when something like that is invented, okay? I think at the very least it's an abuse of discretion, and I think it goes to show that the McKiels were not treated fairly by this trial court in just a blanket denial of their opportunity to receive back their fees and expenses. The judge said the amendment of the pleas was not so substantial so as to constitute an abandonment. But no, that is incorrect, and that you should find that as reversible prejudicial error. The fact is that they did restructure their take, they redefined their take, and that take was such as to cause needed corrections to the strategy and trial approach of the McKiels. And it is something that is a partial abandonment. The case law allows for that to be covered under the attorney's fee statute, expenses statute, and the court's failure to analyze the ordinances and resolutions that existed prior to those that came after for the changes. That was the error, because if the judge had done that, he'd have seen that they changed from the fee simple absolute to a lesser fee. He'd have seen that they did nothing to the legal descriptions, but they did change the estate that was being taken. And that should have been highly significant to him.
Remind me, do you have any 9th District precedent on, that you're citing in support of your arguments there?
Judge, there was a decision that you guys just issued on the 14th, and I just pulled it off the electronic computer. It's a case of Calbra versus Calbra, 217 Ohio 4272.
That was a domestic relations case.
That is correct, and in paragraph 11 states that, and I cite it for the definition of abuse of discretion. An abuse of discretion is found when the trial court is unreasonable or acts in a manner contrary to law or without evidentiary support. And I suggest to you that when the trial court made its findings in this case, when it ruled against the McKiels on August 22nd, 2016, denying their application for fees and costs, that according to the terms of the entry, that the judge was not acting with evidentiary support to the declarations and facts that he was stating in that report. And clearly, he just, for whatever reason, was covering Lorain from having any liability under that statute. And I think it was clearly wrong, clearly an error. Thank you, Your Honors.
May it please the court, I'm Richard Mikowski, representing the city of Lorain this morning. Co-counsel, Assistant Law Director Donna Zaleski is behind me here. Your Honors, the city comes before you with the full record of this case, all of the pleadings that were filed, the exhibits that were attached to all the pleadings in various motions, the trial exhibits that were admitted during the basically 1 week trial, and the information, coupled with the information that Mr. Gargis has referred to, the legislation. And in considering all of those facts and circumstances under the applicable standard of review and the ruling case law on the point of whether there's an abandonment that merits an award of attorney's fees and expenses, that it leads to the conclusion that the trial court clearly and simply did not err in denying the motion for fees. Now, very quickly, the McKiels came before the trial court shortly after the jury verdict was rendered in this case. And the court had questioned Mr. Gargis about the nature of the taking. Attached with the city's brief are exhibits, plan sheets that were admitted during the course of the trial, as well as some aerial photographs that depict the take. Basically, from day one in the project, the plan was to acquire fee simple of the original 20-foot width of right-of-way held by easement, together with the additional 7 feet, and that's what makes up the 5,000 or so square feet off the front of these two adjoining residential properties. This isn't commercial development property, except in the eyes of the McKiel's appraiser, whose testimony was very much limited by the trial judge because of all the inaccuracies and misleading information that she developed. But anyway, it was a 7-foot strip for the purpose of widening the road, installation of sidewalks, and from day one the plans showed the reconstruction of 3 existing drives, 1 back to the McKiel's residence and 2 to a rental property that they owned immediately adjacent to their residence. But at the end of the week trial, the jury returned a verdict of almost $102,000 for both properties. They made decisions of value, compensation and damages on each of the 2 properties. Now, basically the only witnesses who were permitted to testify for the McKiels on value were the McKiels. As property owners, they don't have to come in with an appraiser. Just because they own the property, they're entitled to come and tell the jury what they think it's worth. Their expert appraiser was only permitted to testify about value of the vacant land because of numerous problems with her appraisal report. And at the end of the day, even though the McKiels asked for something over $300,000, the jury returned a total verdict between the 2 of about $102,000, after which the McKiels came back for more public money, seeking attorney's fees and expert witness fees of almost $58,000, more than half the verdict that was rendered in the case. And those expenses went back to a point where the McKiels hired an appraiser and who looked at the plans, looked at the offers that were made, concluded that the total compensation and damages should be about $58,000. And that's a report attached to a motion in limine that we filed to exclude the appraisal testimony of Kevin Riley, who happens to be the law director's brother. But anyway, so at this point, what we need to focus on are a couple narrow issues: the standard of review, the appropriate case law that applies Revised Code 16321, and the facts and information developed within the entire record in this case. Now, Mr. Gargas mentioned a few minutes ago an abuse of discretion standard. In their merit brief, they start out discussing a de novo standard of review, that the decision of whether there was an abandonment was a matter of law. I would point out to the court a case cited within the McKiel's brief, Dublin versus Wershansky, a 10th district case that involved the issue of abandonment under 16321. It wasn't an issue on award of attorney's fees, but whether the city of Dublin could legally abandon a taking once they had gone on the property. And in that decision, at paragraph 21, the appellate court said, "We believe that such a determination under 16321 centers on the facts and circumstances of each individual case. And as such, a trial court should be afforded broad discretion in determining whether the public agency has taken possession of the appropriated property and could effectively abandon, actually file a notice abandoning the appropriation proceeding. Thus, an appellate court should not substitute its judgment for that of the trial court unless its decision amounts to an abuse of discretion." And then they go on to cite the standard Blakemore versus Blakemore cases, and probably follows the standard that Mr. Gargas just mentioned of your recent decision in the domestic relations case. The city agrees that's the appropriate standard of review at this point. Just real quickly, I know that when I was researching that issue, I looked and looked and looked. I was aware of a prior unreported decision. I have copies if the court would indulge me, but it's a case, City of Willoughby versus Slyman, that involves some really unusual circumstances where a road construction project was just shut down, and it sat there for 2 years with no work being done. And the owners came and asked the trial court for award of fees and expenses. And that court indicated, with respect to whether or not the trial court was correct in deciding the city had abandoned the proceedings, we review the decision based on abuse of discretion standard, and again citing to the typical Ohio Supreme Court decisions. Now, with that standard, I would say leading case involving facts similar to what we have in this record is the Dorsey versus Donahue case. It was a road appropriation case involving widening. It was a fee simple taking in which the city had plans demonstrating they were planning to rebuild the driveways, but in filing the pleadings, that reference, the reservation of access rights, was left off the description that was filed in the case. The case started up, it was being developed, and the city came back and sought leave to amend the petition. Leave was granted. I believe Mr. McKiel's cite in their briefs that decision for the authority of a trial court to allow an amendment in an appropriation case. We wholeheartedly agree, and would have asked the court to focus on how the attorney fee issue developed from there, where the case went to trial, there was a jury verdict, the government wasn't satisfied, there was an appeal, the owners cross-appealed on the denial of a motion under 16321. There, the court went through the record and pointed out the plans called for access drives to be restored. The legal description was fee simple, but the city had established it was basically a mistake to not include the phrase reserving rights of access. That there was no bad faith in the city seeking leave to amend in the case, and that the owners were not prejudiced by allowing the amendment. Again, apparently in that case, there was a failed trial strategy that happened. That's where the McKiels are asking the public to pay for their failed trial strategy. In the record in this case, the evidence was developed by means of attachments to a motion, or rather, I'm sorry, a brief filed in opposition to a motion to dismiss the appropriations that the McKiels filed. There was an evidentiary hearing conducted by Judge Walther on that motion to dismiss, where Mr. McKiel testified. And he identified the attachments that are in the brief, which basically were the statutory notice of intent to appropriate and good faith offer, a plan letter attachment, and copies of the plans, all of which explain the intended takings were WD, fee simple, but with a reservation of access. The drives would be rebuilt and access would be retained. We don't have the transcript from that hearing, so I won't go into any length about that, but the exhibits are within the record for the trial court's consideration. Moving ahead from that, we have Mr. Riley's initial valuation report, where he did his valuation based on the plans and the fact that access was going to be preserved, and came up with an opinion of $58,000 for both properties. And then he adds to his analysis based on an instruction from the McKiels: presume that access rights are taken and go from there. Presume that there's flooding caused on the property. Presume that it's necessary to rebuild the bridge on the drive to the McKiels' residence. And with those instructions, he came back with a number of $750,000.
How far back was that bridge from the 7 feet?
40 feet, maybe 40 to 50 feet.
Farther back in from.
Right, it's depicted in the aerial views of the taking that are attached to the brief, Your Honor. And let's see, A7 in the city's appendix, which was Plaintiff's Exhibit 75, it shows there's a creek that crosses through the back end of the rental property and the front of the McKiels' residence. And that bridge spans the creek. His testimony was to be, the trial judge ruled that there were limitations on what he could testify to. Looking at Debbie Wilcox's appraisal, the $700,000 number that Mr. Gargas referred to, again, there are relevant portions of her appraisal report attached to a motion in limine to exclude her testimony based on her initial appraisal. Again, she uses the presumption, no rights of access to the residue, even though she went to the property and saw the project was built. The road was widened, the sidewalks were built, the drives were rebuilt. There wasn't any failure to complete the project, but she took the cue from the City of Westerville versus Taylor case that Mr. Gargas referred to. That was a situation that came up in Franklin County, 10th District decision, where the city did a fee simple taking together with a landscaping easement next to the fee simple take, removed one drive to a bank property. The plans showed the other drives being rebuilt. But the difference in that case is the city never sought leave to amend the petition, but only came to trial arguing, well, the plans showed it, and therefore the jury should consider the impact, damages to the residue based on the plans. The trial court and the appellate court said, no, that doesn't cut it. If it's not expressly reserved, we can't presume the rights are there. That's the trial strategy that the McKiels had in developing their case based on the initial pleadings. What happened here? Your Honors, I wasn't involved at the time the pleadings were developed, that the offer papers were made, and the legal descriptions exchanged. I think it was a simple clerical error. The mechanism that governments use on road takings to identify takings with access rights versus takings reserving access rights is a parcel designation, WD when access rights are to be reserved, WL when they're to be taken or limited. And the way that is done, it doesn't take the surveyor to incorporate that into a meets and bounds description, but there's a leading paragraph placed with the meets and bounds that didn't get attached to that description. But
Are they
again,
seeking in any of your expenses incurred prior to the amendment?
from day one, Your Honor. All of the attorney's fees and the appraisal cost, both the initial ones and the follow-up ones, which weren't admitted before the jury in total. All of the fees and expenses, including a cost for attending a mediation by the appraiser, which never happened at the court. It was a settlement discussion. I'm sorry, Ron. Very basically, based on the Dorsey case, the facts in this record, the standard of law applicable here, we submit that the trial court's ruling denying the motion should be affirmed and conclude the case at that point. Thank you, Your Honors.
Attorney Garnes, you have about 5 minutes left.
Thank you, Your Honors. Your Honors, we filed a motion to dismiss this case to make them start over. That's what we did. The judge had a hearing on it. He said, no, they're going to be allowed to amend their petition. And then we had to proceed on that amendment. I think my adversary has indicated that somehow or another they were allowed to amend and then didn't do, that the changes were not subsequently made. Again, I point out to the court, and this is very important, that the city council passed ordinances and resolutions that declared what was going to be. The lawyers don't have no discretion. They have to follow what the city council establishes by law, ordains. It wasn't until after they filed their motion to amend their complaint that they went back to city council. And on July 20th of 2015, city council passed these new laws. So they had no choice at that point. They had to proceed under the new laws. And those new laws, Your Honor, is what constitutes the new taking. And the new taking, okay, defines what they weren't going to take anymore, what they had previously said they were going to take, and what they gave up, what they abandoned.
So your argument is that because they had to go back and get new resolutions and new laws made by the city of Lorain, that they essentially abandoned the initial one, and now they've got a new one. Even though it's all the same stuff, they had to override the past one?
That is correct. It's not the same stuff, it's the same legal description, but it's a different take. In other words, the estate that the city was taking is much smaller now after they went back and passed the new legislation. Instead of everything fee simple, absolute, the entire bundle of sticks like they told us in law school. They cut the sticks way back. They didn't take the whole bundle. They only took, what they had to take.
You took the whole 5,300 square feet on the one and the 5,400 on the other, right? So the
Right.
actual amount
That's all they really needed to take, but instead of doing that, they decided to take, the whole bundle of sticks, including the reservation that didn't exist for ingress and egress. And they caused more damage than they needed to cause with their original legislation. And we pointed that out to them and said, hey, you guys might be, reputable, but we got to have something that's going to last. What about if the next council comes in, or the next mayor, or the next people that come down the road? They're going to look back to the legislative docket and they're going to say, hey, this is what was passed, this is what we own. That's what counts in this. Not that they were going to do this, or,
So basically what you're saying is, the other side is saying the new resolution was merely to reflect what was already there, and you say, well, it's not already there and you have to put it in, and so since you have to put it in.
Your Honor, it was never there. They took it all. They wanted the whole thing, all the bundle of rights. Fee simple, absolute, and it's in there. And that's why I say, compare Exhibit C to Exhibit B, which is something the trial court erred by not doing, because that demonstrates the take, the real take, and what was abandoned. You know, there's their original take, there's what they ended up taking, and then there's the part that is the abandonment. And all of that is defined in those resolutions and ordinances, Your Honor. There was no failed trial strategy here. I don't know why we're going into, you know, what was motion in limines and all that. None of that is really applicable. What's applicable is the actual law that was passed. And that's what the trial court needed to focus on, and I think the trial court failed to come to the right decision. The case law, we cited the case law, but the case law doesn't say, you know, that just because they can amend it. Okay, I agree, the trial court can allow the amendment, but that law that says that that case that says they can amend it also says that it implicates the provisions of 16321, because they changed the focus, they changed what they were taking. And therefore, the owners have a right under a remedial statute to recover their attorney's fees and costs and expenses. Thank you, Your Honors.
Thank you for your presentations today. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted to our website at